Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Grand jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on Caleb. Dati mihi Anglican for his service like.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Oh, for crumb's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I am the Recovery Addict. I don't know how I should say it today. Wow, I'm exhausted. I'm so tired. Welcome all, welcome one and all. Fran Fitzgerald, congratulations. You were first in chat today. Everything IP related worldwide is your responsibility. Thank you very much. Am I sick? I have a killer headache, but the meds have kicked in, so now I can't feel anything at all. So I think I'm good. Had my daughter-in-law, future daughter-in-law, fly out this morning, so that means we were up at 2:30, and we have a couple kids who are sick that I was up with, so I've been up since about 2:30. I was supposed to stay home and sleep. Mrs. R.A. has slept in yesterday so she could drive. She drove, and she's sleeping now. I stayed up the whole time. I'm exhausted. I'm tired. I am the Recovery Addict. There we go. We'll do we'll emphasize the. As we're getting the birthdays ready, this morning, some of you want to know, you've asked, what goes into being a judge and what's, behind the scenes, what happens there. And we'll address that here in just a little bit. Birthday shout out form. There we go. Schmoopy and Sweet Pea, let's sing to them really quickly. Get that out of the way. Not out of the way because we don't want to do it, but because we want you guys to begin the whole day of celebrations, and you can't start until we sing. So let's go ahead and do that. Oh, that's better. I can hear myself now. Yay. All right. Wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Sing to Schmoopy and Sweet Pea. Happy birthday to you. Happy birthday to you. Happy birthday to Schmoopy and Sweet Pea. Happy birthday to you. Woo! Schmoopy and Sweet Pea, happy birthday to them. Many wonderful days, but today is your special day, and I realize there are a million places you could be and a billion people you could have celebrated with, but you chose to be right here with us. The privilege, pleasure, the honor, the joy, that is ours. But hopefully we can turn that joy right back to you and make your day just a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlap's House, Sandy's Grill, Bob Evans, and Cracker Barrel. Boom! Now we've got a lot of birthday songs that we can just watch the dancers do their thing. And wait for the pancakes to cook. Happy birthday, Schmoopy and Sweet Pea. Super excited for you. I needed that smile. Schmoopy, congratulations. Thank you. Wouldn't be the same without you here. You know that. Got big plans for the birthday? Guess what? Dancers stay for extra practice. Oh, nice. All right. Cha-cha. I want to get this off the screen, but I can't get the other thing off the screen yet. These are some blokes over in England playing a video game. I don't need them, but I need the other one. I don't know which remote's which. I think it's this one. Everyone help me with the air drums for the big finish. Ready? congratulations all. Happy birthday. You guys wondered what goes into being a judge, how one prepares for a day in court. Well, you don't have to wonder anymore, because in Kansas, we've got our defendant ready. I'm not sure if this counts as a hoodie or a tank top or both, but he's got that, and we also have the one eye on screen. So I'm thinking they're like three. Let's see. Oh, Greenwood County Courthouse is getting set. Everyone's getting ready. Got 3 bingo boxes right there. It's definitely a hoodie. It's a hank top. Chairbold lady, what happened to the lieutenant? They paid everything, so it's good. They've turned our driveway into a car repair place, which I wasn't expecting, but it's good, I guess. So far, so good. A sleeveless hoodie. Sleeveless hoodie. Let's just chill for a minute and see if we can get give court a few minutes to get warmed up today. One eye should be an item. Yes. The worst is when they're using their phone. You know they're using their. Oh, I'm very blurry. I mean, I feel blurry, but I look blurry too. When they're using their phone and they hold it like at an angle, and all you get is like this much of their head, like that much, right? And I'm sorry, girls, ladies, it doesn't seem to be a guy thing. The fairer sex seems to be more prone to do that look, and I don't know why.
Good morning, Missy.
Hey, good morning.
Morning.
Is everybody ready, Jill? Missy's here. Where did the defendant go? Where's Jill? Is she at the barber shop? The beautician? What's that big pink ball in the background? I don't know. I don't know why a barber would have a balloon, maybe. Yes, a balloon. I think we're going to go for bingo today. We're just going to surf our favorite courts and find all the bingo items we can. Louisiana parole hearings has a good one right now. We'll take a gander over there in a minute. Possibly next. Let's see. Yeah, we'll do a quick check over there. Louisiana Parole Board. All right. Hey, Judge Webster's ready. Judge, you ready to start? Don't think she's ready. She's almost ready. There we go. There we go. Get the judicial brush out, the judicial mirror. Justice must happen, and we must look our best for it. That's all we wanted. That's all I wanted. She looks great. Using the court zoom. Oh, wait, there's more. There's more.
All right, is that Mr. Clater there at the courthouse?
Yes, it is.
And you don't have an attorney for this hearing, sir?
I was supposed to be getting Mr. Joseph Favre again and everything. I worked on trying to contact him. Every time I tried calling him in the mornings before I went to work and stuff, I would get sent to voicemail, and had said his voicemail box was full, so I wasn't able to leave mail and everything. So I haven't been in contact with him yet, and
Well,
everything.
So you're planning on going without an attorney today then?
If he's not here, then I guess I'm gonna have to.
Missy, have you heard anything from Mr. Favre?
Well, he said he would take the case, and I reappointed him. I just emailed him to see if he was stuck in somebody else's court, but
We
I
saw
haven't
him
heard back
yesterday.
yet.
Miss Gillette, have you heard anything from Mr. Favre about this matter? And I've lost her too.
Attorney no-show on the bingo
Mr.
card.
Clater did email me this morning a screenshot of a receipt saying that he paid his
Well, Miss Gillette, is that the only thing you were concerned about on the show cause hearing was payment? I mean, he's still showing a financial balance of $878, but apparently he's paid that, Missy, all of it.
Well, it went to collections, so I have a screenshot here which I can screen share.
Okay, before we go on the record, why don't you go ahead and do that?
Okay.
I don't know, Miss
If
Gillette.
if it is any consolation, on here it does say principal total balance was 878. I'm guessing that's what the balance was before it got sent over to collections. And then it
Constellation?
said total charges occurred $308.49. I'm guessing that's what got tagged on with the original charge. And I paid the full balance that it said of $1,184 this morning. And that's what I paid. And one of the screenshots, that's the screenshot from my Cash App right there from where I paid it. And then there should be two more. One of them should show where it shows that I have.
Hold up. Let's make sure we're officially on the record. I wasn't going to, but if you're gonna just yet, but if you're gonna go into all that, we will. We are on the record now in GW 2023 CR 21, State of Kansas versus Cody Michael Clater, County Attorney Jill Gillette for the state. Mr. Clater appears in person and pro se, having been appointed counsel, but unable to connect with that attorney. That attorney being Joseph Favre, who represented Mr. Clater previously on this case. Now, we have a warrant to show cause today. I'm looking at the warrant filed May 26th to 26th based on the request for revocation. And it alleges that the defendant, Cody Clater, having been convicted for possession of marijuana on July 28th, 2024, has violated his probation.
Oh, and she's gone. Just that quick. Okay, we're gonna jump over to the board here really quickly to see what happens here.
Hello?
Then we're gonna go to McNally.
Yeah, can you hear me?
Yes, sir.
With the staff there, state their name for the record, please.
Deputy Long.
Thank you. My name is Chuck Tillis. I'm chairing today's committee.
It says
My colleagues
Steve
are on
Prater.
Zoom, Ms. Jerry Leduc and Mr. Steve Prater. Would you state your name and DOC number for the record, please?
Oh, I thought it was the other guy.
Bertrand, number 623647.
Okay, do you have a questionnaire with you today?
Excuse me?
Do you have a questionnaire with you today that you signed?
No, sir, I don't have it on.
Okay, we're gonna put it out. Is that your signature?
Yes,
Do you wish to continue this hearing today?
yes, sir.
Okay. Today, Mr. Prater will be handling your case, and I'm going to turn it over to Mr. Prater.
Hey, Red. It's definitely
Okay, Mr.
we're
Bertrand.
getting ejected from the court.
When
so-
you're released from jail on parole, you agree to abide by certain conditions. Today, we're here to discuss your violation or your suspected violations of condition 4 and condition 10. Let's go with number 10 first. It says that you owe $315 in back fees. Is that correct?
That's correct.
And so you plead guilty to that?
Yes, sir.
Okay. Well, let's move on to the more serious one. The first, there's two of them on number 4. One is that you you failed a drug screen or admitted that you would fail a drug screen for PCP on September the 15th of 2025. Is that correct?
That's correct.
Okay, so you're pleading guilty to number 4.
Yes.
And the other number 4, the same condition but a different situation.
Yes, 2 number 4s.
Took place where you were charged with indecent behavior with a juvenile, and that charge has subsequently been null-prossed. And we're aware of that, and we have all the reports. But were you charged with that?
Yes, sir. They charged me.
Were you guilty of that?
No, sir.
Okay. So we want to talk about, mainly we want to talk about that particular deal. I've read all the reports several times. It's a very convoluted deal, and I see we have someone that's going to speak to us on that matter in just a little while. And so we're going to let them speak to us. But would you tell me what the situation is before we talk to them?
Yes, yes, sir. I woke up in the morning and I went to their apartment to talk to my brother. And then when I went in there, my brother was asleep first. And I went in the kitchen, to get something to drink. And then when I come out, the girl and my brother are arguing. So my brother leave out the apartment. And I picked the baby up and the baby was crying. And the girl was crying too, so she gave me a hug. She gave me a hug while I was holding the baby. Then, you know, the mother came in and she thought otherwise.
Okay, and the mother is going to be talking to us today. Is that correct?
Yes, sir, I see so.
And what is her name?
Maria.
Okay.
It's Motorola.
All right, so you're saying you and the 16-year-old girl just hugged, correct?
Correct.
Okay. And we also have a couple of other people that are going to be speaking today, but I'd rather go ahead and get into this and get this cleared up to where we have an understanding of it before we talk to the other supporters of you not being revoked. So let's see, Miss Surfia, am I saying that right?
Yeah.
Miss Surfia, you're muted. There you go. Would you tell us about your relationship with this fella and tell us what you witnessed and what you're thinking?
Good morning. Well, we was in the past like maybe 2 years, we was talking only for a few days. It was like a relationship, but only like few days. So.
Okay, so you and Shannon had a relationship?
Yes, we was in a relationship.
Okay, and the 16-year-old the one he's accused of is related to you, is that correct?
Yeah, she's my daughter. Yeah.
Okay, that's your daughter, and you came in and saw them hugging and called the police, correct?
Yes.
Okay, now the charges have since been dropped, and you had something to do with that, correct?
Yes.
Tell me about that.
How you say?
Tell me about that. Tell me what happened and what you feel like happened now and what your involvement now.
Well, the day I was working and Shannon go to visit his brother, right? So they was talking, and then my daughter and Mike was arguing, and Shannon was visit him. So he was hugging the baby, and when I come home, he was there, and my daughter was like giving a hug to him, but maybe they was talking like, something like telling, hey, don't worry because my arguing with you or something. But I'm very restricted woman and very what to say, protective mother, you know. So I was thinking divorce because, you know, yeah, but was a misunderstanding. I talked to my daughter and say, hey, what happened? You know, she never lied to me. So I talked to her and she tell me, Mom, nothing happened. So he only was talking to me, you know, about things of mine, don't argue with mine, and way me come home and everything.
So you don't think anything, now you don't think anything happened?
Well, I talked to my daughter. She never lied to me. You know, I show her always tell me the truth. And I believe in my daughter, you know. So she tell me, because I tell her, hey, you need to tell me the truth, you know. And she said, Ma, and say, hey, look at my eyes, Melissa, and tell me the truth. So she talked to me. She said, Ma, nothing happened. Ma, I promise you nothing happened. And we know was like talking a kind of way or something. Yeah. So.
Okay.
Do you have a relationship with him now?
With who?
With Mr. Bertrand.
With Shannon?
Yeah.
No, we don't do that. Like, no, we don't got a relationship.
Okay. Why was he at your house?
How you say?
Why was he at your house with your daughter?
He was with my daughter in my house?
Yeah.
Well, he go visit the brother. And you don't know, I can control if the brother go there, you know, to visit the brother.
And the brother goes with your daughter, correct?
How? Like you say, he stay in the house?
Do they date or anything?
The brother's dating a 16-year-old?
You're talking about Mike?
About your daughter and
yeah, my daughter.
And Mr. Bertrand's brother.
Okay.
Do they see each other? Do they
Yes.
date?
Yes, they.
How old is Mr. Bertrand's brother?
He's almost 40. Today
He's
40.
What?
He's 40 and your daughter is 16?
She talked to the brother. She misunderstanding what he's saying. She didn't want to talk to my brother, Maria.
Oh, you say Shannon? Shannon, how? He's 38. I think so.
Okay, he's 38 and your daughter is 16, correct?
Yes, correct.
Do they have a relationship? Is that what you're saying? Or you have a relationship with him, the brother?
Me?
Why is the brother at your house?
Well, look, me and Shannon was talking for a few days. You know, when I come from New York, we was talking, you know, and then we was talking then, like, you know, like maybe like friends or something, you know, and then I meet Mike, is his brother, Mike, you know, Mike. So he was living there too, because I was with him.
Okay.
With my baby daddy, you know. It's Shannon's brother.
The baby daddy
is Mike.
Yeah, it's Mike. It's
is Mike
okay.
Bertrand?
Okay.
Yes, sir. Yes.
Okay. Okay, and so Shannon was over there seeing Mike.
Yeah.
And the baby, and your 16-year-old daughter was there.
Yeah, exactly.
Okay, that's what I was trying to. The report is somewhat confusing about that issue, and I couldn't quite figure it out. Okay. All right. Well, we might come back to you, but let me go back to Mr. Bertrand.
Shannon's is
Mr.
orange.
Bertrand, let's talk a minute about the failed drug screen when you admitted that you would fail it because of PCP. Have you ever gotten any treatment for the drugs?
No, sir. I was telling my parole officer I was going to go to the outpatient treatment, but the outpatient treatment wanted to charge me some money I ain't have. So I was my next plan was to go do some inpatient, then go to sober living.
Okay. How long have you been locked up?
Since November 1st.
Have you had any drugs since November?
No, sir.
Have you had a drug test since November?
No, sir. I've been incarcerated. No, sir.
How much longer do you have on your sentence? You got to be in jail until the 20. If you do all of your time, you'll be locked up until 2028. Correct?
Yes, sir.
Okay.
So he's got 2 more years.
All right. Well, let's hear from Shalisa Bertrand. Miss Shalisa, would you talk to us?
Yes, sir. Good morning.
Shalisa.
My name is Shalisa Bertrand. I am Shannon Bertrand's sister. Thank you for giving me the opportunity to speak today. I want to share what I have personally witnessed about Shannon and the person I know him to be. Like many people, Shannon has gone through difficult periods in his life. He's made mistakes, and I understand that he is responsible for the choices he made. I am not here to make excuses for him or to speak about anyone else. I simply want the board to know the man I have known my entire life. Shannon is a caring brother, a devoted father, and someone who has always loved his family. He is kind-hearted, and he has always been willing to help his family and the people that he loved. His actions during one period of his life do not define the person he truly is. One of Shannon's greatest source of pride is his son. This month, his son will begin college on a baseball scholarship, an achievement that reflects years of hard work and dedication. Shannon is incredibly proud of him and wants the opportunity to continue supporting and encouraging him as he begins his important new chapter in his life. Family has always been important to Shannon, and he wants to be a positive presence for his children and loved ones. Over the years, I have seen Shannon mature and reflect on the decisions that brought him here.
She almost said something else.
I believe he has learned from his past and is committed to making a better choice in the future. He is given the opportunity to return home. Our family is fully prepared to support him, hold him accountable, and help him continue on a positive path. I respectfully ask the board to consider the whole person, not just the worst chapter of his life. And I believe Shannon has the ability to be productive and responsible member of the community, and our family will stand beside him every step of the way. Thank you for your time, your service, and your consideration for my statement.
Okay, thank you for
Still
those
can't
words.
get over
We
the whole
appreciate
Shannon
that.
and Mike dating the same person.
Hear from Adeline Bertrand. Miss Adeline Bertrand.
Is she on?
My mom, she's working at the plant, and she probably had to step off, so she asked so I don't know. That's probably what it is.
So she may not be able to speak to us at this particular time.
Yeah, she hasn't got on.
Okay.
Okay, I'm on mute. Can y'all hear me? Okay. I had to turn the camera off because of where I'm working at, but I'm here.
Okay.
Okay. Okay, I'm gonna speak on behalf of my son Shannon Bertrand, as I call him McBride. He's my second born. He's the one that is more like me, the one his heart is, and I'm not just saying that. Shannon has a big heart. And sometimes I get upset with him because he have a tendency of putting others before him. That is where me and him fall out. But over the time, I saw Shannon make better decisions and everything, and he's learning to put himself first. Shannon will run out to go see about a friend, a brother, or sister before thinking about himself. And sometimes that had led him in situations that he shouldn't be in, caring too much. Shannon, when he put his mind to things, he's over accomplished. Shannon has the NCC PR in rigor certification in rigor. Shannon also has a certification for small motor repairs. Shannon always been my honor roll student in school. Shannon is the one that if I'm sick or if anyone is sick in the house, he's the first one to notice. He's the one to clean up, and he gets nervous around dirtiness. But my thing is, I've seen growth in him. I know the core of this young man. Over the time of being locked up, I've seen that it took a toll on him. The last time he was home, I see the slowness in him and everything. And I as a mother, I see the toll that it took. I look in his eyes. I could see he's tired. And I told Shannon, I said, Shannon, the thing that gets you in trouble when somebody calls you, you go and see about them no matter what. And no matter what. And I see it all the time, but I know Shannon had made progress. He likes to work and go home and read. The only way he roll out that house if his brother or sister's calling him. He's going to see about him. But he's a good father. You know, nobody's perfect and everything. But when Shannon have a whole army of support, where I'm working at right now, I spoke with someone to kind of help him get his feet in the door. I'm at the plant with Shannon certification and everything. They have people that is willing to help him with that. I just hope that you can find it in your heart to let him come home. I just hope that I know he's ready to to move forward in a positive direction. And I just want Shannon to put himself first and not to always go run with everybody calling him, and he's getting a lot better. I've seen an improvement on that, and his heart is too big. Too big. That's what me and him draw the line. My heart is not that big. But I'm hoping that you do take in consideration to let him come home and be with his family. He do have a stable place to live. My support, we will support him and encourage him, with all the conditions of his parole. We, as I'm speaking of me and his family, we're committed to helping him stay focused. And I do have a job lined up for him to build a better future, and so he could be involved in his children's life.
Okay, thank you. Thank you.
You're
We
welcome.
appreciate those words. All right, Mr. Bertrand, it sounds like we got two problems here. One we got is the money, which we're not going to trust that you're going to get that paid back. So we're not going to take that off the table for now. The other is the drug problem is important to me because I think that's the crux to your problems. And just because you've been drug free, as you claim, for the last months, doesn't mean that you're out of the woods at all. So if I was to vote to not revoke you, but require you to find and fund, whether it be your family help you or whatever, a drug treatment program, and that you would attend AA meetings 3 days a week, and that you would stay away from this 16-year-old and her mother and their residents, and stay completely away from them with something like a ordered protective order, but we're going to order it from the board. Would you be willing to do that?
Yes, sir.
Stay away from the 16, please.
I already had like the goal already to end the drug treatment and get all the help I need, yes, sir, I'd be glad to cooperate.
Yeah, one person
Okay.
takes the
Well,
lead, and then
that's
the
what
other two
I'm
will
thinking,
vote.
but I want to hear what my board members, what questions they might have, and see what suggestions they might have also, because the three of us work very well together, and we work to try to find out what's best for the folks that we're talking to. So, Mr. Chairman, that's all the questions I have.
Thank you, Mr. Prater. Ms. Ledoux, do you have any questions?
I do not, thank you.
Mr. Prater, are you prepared to vote?
Yes, sir, I am. Okay, my vote is to not revoke you, but to require you to immediately, within 2 weeks, find you a drug treatment program, a drug substance abuse treatment program, and to attend it regularly and all sessions, and it to be funded within 30 days of you being released. And in the meantime, and afterwards, that you attend AA meetings or NA meetings 3 days a week for the next 6 months.
Okay.
And that you stay completely away from the reported complainant or victim in this case. You have nothing to do with her. Do not go over to that house or meet her anywhere or talk to her on the phone or have any contact with her or her mother at any time ever. Now, do you agree with those stipulations? I guess that would be in lieu of revocation. I'm not sure how we'll list it on the chart, but that's the requirements. Do you understand that?
Yes, sir, I understand.
Okay. Board members, that's my vote. And if you think you need to fine tune any of the requirements for me, that'd be fine too. And we'll vote.
It's a long vote.
Thank you, Mr. Prater. Ms. Ledoux?
Concur.
And I also concur.
All right, he gets it.
Mr. Humphrey?
He's not revoked.
Your parole has not been revoked today, and you'll have to follow those stipulations as Mr. Prater stated. This ends our business at the Calfee Shoe.
That's quick. All right, let's jump to Judge McNally, where we said we were going to go next. Judge McNally has a hearing this morning. I have no idea what it's about, but we're going to find out. Keep your bingo cards handy. Let's see what we can check off.
People against Michaela Nicole Trammell, 26F716074.
Good morning, Judge and staff. John Graziani, appearing on behalf of Michaela Trammell. She's actually, Judge, I apologize. She's actually at Naomi's Nest right now.
Okay. Ma'am, your name?
Treatment
Center.
Trammell. All right. So this is going to be a plea to, in your appearance, Mr. Graziani?
Again, John Graziani, appearing on behalf of Michaela Trammell. Please identify yourself, Michaela.
I am Michaela Trammell.
All right. So she's going to plead as charged to retail fraud with the plea to be taken under section 771.1. I don't know about this.
Judge, he may have been charged with something like that previously, but it was reduced to, I believe, a disorderly. So I do believe she does qualify for that.
Mrs. Morrow, you pre-tried this, right? Your name?
Nothing has her.
Well, we gotta, yeah, I'm not gonna do this. I mean, there's no way I'm doing this. She's got felony convictions. She's got disorderly plea. She's got different drug offenses. I'm just not going to take it under 771.1.
May I speak with her then?
Sure.
Minutes and then we'll-
Sure.
Judge, if you have nothing else to call, we have already on lookout. She's all gold and on witness with exam.
Okay, let's do it. I'll pass this case. Ma'am, your lawyer's going to go in and call You okay?
Thank you.
That's almost the judge rejecting a plea deal. I think that's on the.
People against Aaron Raymond LaBelle, 267-703-624. Why are you guys in the wrong spaces here?
I know, we just screwed that up.
Good back.
There you go. All right. Your appearance?
Not to ever about the people.
Aaron Aaron, you have yours? Yes, Aaron LaBelle.
All right. You can have a seat, sir. So we're going to proceed to exam on this, correct?
Yes.
The charge is OWI 3. Let me just double check the complaint here real quick. Yeah, we got an operating while intoxicated. Third offense, NA drive while suspended, revoked, denied. So the only thing we're going to have the exam on is the operating while intoxicated. Any preliminary matters?
My understanding the defense counsel has stipulated the MSP lab report that showed the defendant's blood alcohol results at 0.136 grams of alcohol per 100 milliliters of blood.
All right.
For exam purposes only.
Are you going to have the toxicology report marked and received, or?
I do have the report.
You don't have to if you don't want to, as long as you guys stipulate to the blood draw.
We stipulate.
Okay, so for exam purposes, the court will consider that the lab report indicates the defendant had 0.136 blood alcohol level when the blood draw was performed on January the 1st, correct, at 26?
That's correct.
Any other preliminary matters? And any from the defense?
No.
All right, you can call your first witness.
Officer Arnold.
Okay, come on up here, sir. And I will ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So help you God.
I do.
Okay, have a seat.
We should get some dash cam here.
Thank you. And good morning, Officer Ricardo. Officer, can you tell us where you're employed?
Flower Police Department.
And what do you do in the police department?
I patrol the city.
Okay, how long have you been in office for?
Approximately a year now.
Okay, and were you employed as an officer on January 1st, 2026?
Yes, ma'am.
Okay, and what date is January 1st, 2026?
Sorry, what was that?
Were you working on January 1st, 2026?
Yes.
Okay, what were you doing? Well, what were you assigned to do that day?
Patrol the streets, make sure that everyone's calm.
Keep Gotham safe. Like Batman.
And then were you at near Arsenal Road in Rockbridge Court?
Yes, sir.
Is that in the city of Flower County, Blaine?
Yes, ma'am.
Okay, why were you in that area?
Because I was a police officer for Flower.
I'm just going to ask you to
speak up.
Pull in a little bit and just keep your voice up nice and loud for me, okay?
Kurt Smith, thank you very much for being a member. Welcome.
Yes.
What did you do?
In front of 26800 Arsenal Street. I was traveling northbound on Arsenal Road, and I observed a blue Ford Explorer and what appeared to be the front yard in front of that address, a blue Ford Explorer that was running. It was occupied. There was smoke coming from the exhaust. That's what I observed.
Okay, why was that significant to you, or why did that flag your attention?
I saw tire tracks going into a driveway, and then there was just a vehicle off to the left of those tire tracks inside of the front yard in front of the residence, which was 26800.
What did you do after you observed this?
I approached the vehicle and I observed our suspect in the driver's seat with the lights illuminated on the dash, and the vehicle would be running. It wasn't in park, so I knocked on the window multiple times to check it.
Were you able to observe whether that vehicle was in park before you approached the window?
Yes.
Okay, how long was it not in park for?
I didn't answer that.
Okay, and then why is it that you decided to approach the driver's side window or the car in general?
It was weird for me to see a vehicle parked in a front yard, not pulled into the driveway. It was very late at night. I can't recall the exact time.
Okay, late at night, was it into the AM?
Into the day.
Okay, and then you stated that the vehicle was occupied. How many individuals were in the vehicle?
One individual.
Would you recognize that individual if you saw him here today?
I do.
Could you take a look around the board and point out and identify a piece of clothing they are wearing?
Gray, collar shirt.
You are this time of the record one would identify Mr. Logan.
The record should so reflect.
Thank you. And what happened when you approached Mr. Logan?
Knocked down the driver's side window multiple times. He appeared to be sleeping in the front seat. He would not answer to me. I announced myself as Officer Ricardo with the Flatiron Police multiple times, pounding on the window, trying to get him to wake up. I wasn't sure if it was a medical issue, wasn't sure what was going on. And eventually, after knocking and announcing on the window multiple times, he woke up and rolled down the window and spoke with me.
Okay, when he rolled the window down, what anything did you?
Did open air sniff?
He seemed very disoriented. He had slurred speech. He could barely hold his eyes open. His eyes were bloodshot and watery.
It's like me this morning.
To you?
Intoxicated driver.
Okay, do you have any training and experience in drivers who could potentially be intoxicated or under the influence?
I did.
And what is that?
I had OWI training throughout my academy that I did receive certification for.
Okay. And then what did you do based on your observations?
I spoke with him. I asked him for his driver's license, which he fumbled his cards around, and it took him a little bit to find it, but he did eventually find his license. After observing what I observed, I asked him to step out of the vehicle because I had observed that he was intoxicated.
Okay. Did you smell anything?
I did. I had a strong odor of intoxicants coming from his lips.
Okay, after you stepped out of the vehicle, what did you do?
I conducted SFS tests. I asked him all the medical questions. I stated he wasn't a diabetic.
Which tests did you conduct?
I conducted horizontal gauge nystagmus, walk and turn, and the low medicine.
Okay, and then was Mr. Lobel able to complete each one of these tests? Did he agree to completing these tests?
He agreed to.
You start with the horizontal gaze and nystagmus test?
Yes, I did.
Could you just provide a brief description of that test?
Yep. Would you like me to?
Just a brief description of what you're supposed to do.
Okay. What I do, I hold the stimulus to about approximately or between 12 and 15 inches in front of the face and move it left to right, pausing at some points.
And did you give Mr. Lobel directions to how to complete this test?
Yes, I did.
Okay, and did he perform this test?
Yes, I did.
And then did you make any observations while he performed this test?
Yes, I did.
What observations did he make?
He had nystagmus at maximum deviation. He had nystagmus prior to 45 degrees.
His eyes were jumpy.
That's all I can recall.
Okay, what is it that means?
It will show the eyes bouncing, and that will show.
Really, an objection. He's not been. He's not testifying as an expert. He just as a police officer, and he's giving expert testimony right now.
Judge, I don't believe Lobel was testifying that the defendant's eyes were bouncing or his expert testimony.
Yeah, I don't either. It's overruled. You can continue your answer, sir.
Good try there, defense.
You stated that his eyes were bouncing, and then what else did you observe?
I need to go somewhere else.
That just indicates intoxication for us.
Okay, and then you stated that there was no more tests. What was the second test that you had Mr. Lobel perform?
The walking turn test.
Okay, could you provide, what direction did you give Mr. Lobel?
I got him into the starting position, and I asked him to stay in that position until I demonstrated the test for him, which I did do. While I was demonstrating the test, he could not maintain the starting position.
You could not maintain what?
He couldn't maintain the starting position.
Okay. Did you provide us direction as to how, you stated that you didn't provide direction as to how to complete it. Do you know if Mr. Lobel understood how to complete this test?
I did ask him if he understood.
Did he state that he did?
Yes.
Okay, what observations did you make? You stated that he wasn't able to stand at the starting point. What else, if anything?
Correct. While he was doing his portion of the test, he failed to touch heel to toe, and he didn't count his steps out loud.
Okay. And do you know if Mr. LaBelle had any medical issues or anything? Did you ask whether he had anything that could hinder his performance on that test?
Yes, I did. I asked him if he was a diabetic. He said he wasn't a diabetic. So
I guess that's the only thing that could affect
if he had any issues with walking or anything that would hinder him from participating in the test. He stated that he did not.
Okay. And then the observations that you made during this walk and turn test, what were those indicative of to you?
Investigation.
Okay. And you stated that there was a third test as well. What was the third test that you performed or had Mr. LaBelle perform?
The one with the sand.
Okay. And then what direction did you provide?
I demonstrated the test, and so I got him in started position as well. And then I demonstrated the test for him, and after demonstrating the test, I asked him if he understood, which he said that it.
Okay. And then was Mr. LaBelle able to successfully perform this test?
Sorry.
Was Mr. LaBelle able to successfully perform this test?
He participated in the test. I observed that he was swaying and he could not maintain his balance on the low.
And what is that kind of
Oxidation.
And then, based on these standardized field sobriety tests, what if anything did you do after that?
I offered him a PBT, to which he refused. And then I placed.
You refused to blow
locking handcuffs to replace my methadone.
in the breathalyzer.
You
can get your license revoked.
Yes, he was.
And what was he placed under arrest for?
OWI.
Okay, and do you know if there was a blood draw?
It was a blood draw.
Okay, was there a search warrant for this blood?
There was a search.
Okay, and then, where did the blood draw take place?
At Fort Wiltern.
Okay, was Mr. LaBelle, was he transported to Orwell?
Yes, ma'am.
Okay.
What was
Then,
the amount, percentage?
Did you observe Mr. LaBelle's blood being drawn?
I did.
And then did you do anything else following that?
Yes, the sticker was placed on the blood kit box. I initialed it, and then we sent it off to the lab.
Okay.
And I believe that the nurse also initialed.
Okay, and then was Mr. LaBelle taken back to the police department after that?
Yes, ma'am.
Okay, and did you have any other involvement following that?
I didn't.
Okay, please understand.
Ross? Yes, Sean. Can I have the password for the internet, for the Wi-Fi, excuse me?
Mid-hearing. Can we all have the password to the Wi-Fi?
RB. This.
The guy in back writes down the password to the Wi-Fi in his notebook. It's like, that could be useful. The judge is not impressed.
All right, so I'm trying to leave.
That's a huge laptop.
On the night you pulled, it was January 1st, is that correct? Or morning of January 1st? Did you have any reports of any erratic driving or anyone driving in a crazy manner or some sort of indication someone was driving drunk that night?
I did not.
So you came upon Mr. LaBelle's car just in your normal course of patrol the city?
Correct.
It wasn't driving, it wasn't on a public road, correct?
Correct.
And you had, again, there was no indications, there were any smart marks in the street you observed?
Not at the time. Not that I can keep on.
And do you have your report with you?
I did.
Did you write that report?
I did write the report.
Are you familiar with what the report says?
Yes.
At some point in that report, did you indicate that Mr. LaBelle's car was found in a ditch?
I did.
Okay. I showed you a video earlier.
But it wasn't.
You still believe the car was in a ditch?
I would call it a ditch.
Okay. And so I'm setting the parts of connected to the Wi-Fi. I'm going to shoot a video. Now you took a video that was taken that was with your body cam, is that correct?
Correct.
And as far as you're concerned, the night the body cam was on, that was working properly, correct?
Correct.
And you don't know of any issues with it?
Nope.
And it's a fair, as far as you know, that's a fair indication of what was happening that evening, right? Right? Fair record of it?
Yes, sir.
Got a couple options here. Greeners has done something fantastic, and
Yes, you may.
has found a new letter by Sarah Boone that needs to be read. We have that ready.
So,
Judge Stevens
you see where the
is
car is,
starting
correct?
a trial.
Correct. And you'll agree on the left side of the car, there's a ditch there, correct?
Correct.
Car's not in that ditch, is it?
Wait a second.
Do you want me to share your screen so we don't?
Yeah, I'm having a hard time doing it.
Oh, are you on Zoom?
What? My internet's not connected for me. Reason.
Oh, okay.
Let me call Shane.
Please, and let's go off. Right. Yeah, let's go off the record. We'll call.
Okay.
Send it to me. I can screen share.
That's all we needed. That's all we needed.
I'm sorry, Lisa.
We had
If
call
you send
IT.
it to me, I can screen share.
You want to send it to Lisa at 33court.com?
We got a bingo, another bingo square for call IT into the courtroom. And now we're gonna jump because this case is not extremely interesting. I apologize. We jumped over here, but it's just
But may I grab my laptop?
it's not spicy.
Sorry?
May I grab my laptop? It could work on mine because I shared videos and
Whatever you guys want to do. Look, I'll just get off the bench here.
Okay.
You figure it out and I'll come back, okay? Stay seated, everybody.
You guys stay there. Judge leaves. To think Judge leaves is another one. All right, Judge is gone. We're going to bail on that one. Well, the judge is gone. He will never know that we left. He won't be offended. Promise. All right, now we have to go over to our handwritten letter from Sarah Boone. I have not pre-read this. This is going to be brand new for all of us. So I don't even know what it's about. But Greeners, thank you, my friend, for finding this. He keeps the ear to the ground. He's a great sleuth and true crime doc hunter. All right, District of Court of Appeal, 6th District, East Main Street, 811 East Main Street, Lakeland, Florida, regarding Sarah Boone versus State of Florida. You recognize the handwriting already, right? It's a nothing burger. Dear Sir, Madame of the 6th DCA, in my good faith efforts to abide in accordance with the order given by the DCA to not contact the courts directly, oh my goodness, and advising me to utilize my court-appointed attorney instead, in my own advocacy, I must ignore these instructions. As I do not know whom else I am to turn to in this matter. Enclosed with this letter, I have included a copy of the first written communication I received from my court-appointed attorney, David Maldonado, where he clearly states he has had no intention of simply even reading the state's answer to my brief, much less respond to in my rightful opportunities to do so. His exclusive decision to relinquish his legal responsibilities limits my rights to move forward properly in my defense. Above all, Mr. Maldonado's defeating decision was made well before the state's answer was ever written. This is deeply concerning, as a reply brief can only be meaningfully evaluated after a proper review of the state's arguments, yet my counsel predetermined no response would be filed regardless of what their response would be. His unconcerned approach heavily impedes and prejudices my appeal by restricting any new arguments proving factual inaccuracies, legal misstatements, and my rights altogether. It is my understanding there are significant issues that need to be raised and properly argued in my case, which cannot be for Mr. Maldonado prematurely surrendering his duties as my defense counsel. This approach also raises legitimate questions as to the level of professional diligence, effort, and careful consideration devoted to the successful preparation of my initial brief as a whole, if counsel had already decided, before seeing the opposing party's position, that no additional advocacy was necessary. She's using all the big words today. I have done everything I know how and have the resources to consistently attempt to work with, rely on, be included by my appellate attorney as the court would expect, due to Mr. Maldonado making clear his position in the written refusal to act any further on my behalf has forced me in my responsibility, right, and as a party also in the justice system, being the appellant, to make the court aware of my critical situation. In all due respect, I ask for understanding in my direct contact and graciously seek guidance from the 6th DCA in this matter. Sincerely, Sarah Boone. Copies mailed to said attorney, Orange County Clerk of Court, and Kaylee D. Tatman, Assistant Attorney General in Daytona Beach, Florida. All right, we do also have an attachment from the Maldonado Law Firm, Attorneys and Counselors at Law, from David Maldonado. Wow, this letterhead is something else. I guess if you're a lawyer, you get fancy paper. I'm sure there's a watermark too somewhere. Let's see. Regarding Boone v. State Appeal, Mrs. Boone, I've received your letter dated May 13th, 2026, wherein you state you did not receive a copy of the brief I filed on your behalf. I am not sure why you did not receive that copy, as I had definitely mailed a copy to you as soon as I filed it. So I'm enclosing another copy herein in the hopes that you actually received this one. With respect to the phone call, and as I made you aware during our last call, I ordinarily do not call inmate appeal clients on court-appointed cases, as I prefer written communications. I simply do not have the time or resources on this case to schedule yet another call to discuss the brief, as the brief is self-explanatory, and I made the best arguments I could on this case in light of all the circumstances. As far as to what to expect next on the appeal, the state will have an opportunity to file an answer brief, and the matter will then go before the appellate court for review based on the briefs submitted. I will not be filing any reply brief, and also will not be scheduling any oral argument, as I do not believe it is necessary in this matter. And oral arguments are generally not granted on these matters anyways from the appellate courts. With respect to your wish for me to keep Nicole Ray Feibiger informed as to what transpires with your case, enclosed herein is an attorney-client privilege waiver for your completion. Please review the waiver, sign it, and mail it back to me at your earliest convenience. Once I receive it, I will be happy to provide her with a brief as well, and I can correspond with her to keep her appraised of any updates. Sincerely, David Maldonado. And he spent 78 cents mailing that to her at her permanent address in Orange County. Oh, that's the Orange County Clerk of Court. She spent 78 cents mailing it from her permanent address at Lowell. All right. So, I know this comes as a surprise to you, but Sarah Boone is not happy with her attorney. Again, it's happened again. Oh my goodness. All right. Now we're going to go to Judge Stevens. I know in the other case we've got like the.
So you would agree that that sort was there when you first made
body cam stuff, but it's not super interesting, honestly. Sorry. Judge Stevens has a little trial that's starting. We've been with Judge Stevens recently, and we're going to go back now. Looks like we have a familiar face there on defense as well. That an iPad? What did you put on the desk there? Looks super thick. Let me check and see. I think there's a time. Let's see. It starts about 1:21. So we're about to kick it off right now. It's a Dell. It's a Dell. Okay. So the screen just went dark. So it's like a laptop where the screen can flip around and be a tablet as well, I think. It's a transformer computer. We're just chilling. I think we're going to fast forward a little bit. Got a bailiff there in front of the camera. Oh, here we go. Judge is here. Georgia fan sent the details to Mod Chat. Let me look really quickly. Mod Chat. Three counts of aggravated assault in this case. This is, okay, January 11th is when this happened this year, I believe. At Last Call Liquor. That sounds like a place where great decisions are routinely made. Last Call Liquor. Trevontae Nichols was charged with aggravated assault following the January 11th shooting in Port Arthur, Texas, where he allegedly fired multiple rounds at a vehicle carrying a man, a woman, and a 7-month-old child.
We usually lower it down as low as we can get it, so when you sit down, you disappear. I wasn't here at the meeting last night.
Surveillance.
You sure? I see a lot of crumbs.
We have the kids in here. That's all we start.
Somebody ate cupcakes in the judge's chair. Surveillance video reportedly showed Nichols inside the liquor store wearing a red and white sweatsuit and becoming upset after seeing the male victim.
Okay, he's not here.
Yeah, I need the guy.
Hey, Daryl Lewis?
He's the one who said next week was sick.
Daryl Lewis. Daryl Lewis, no answer in the courtroom. I asked the bailiff to call into the hall for Daryl Lucas, please.
Nichols was seen running after the victim's gray Buick while firing multiple shots.
I'm going to give you a test. Pronounce your client's name 3 times quickly.
Ayala Samaya Zula. He's like, got it. Ayala Samaya Zula. Ayala Samaya Zula. Lakshana. The person.
Do you know there are 8 syllables in the last name of that person? Isn't that amazing?
I think every time she comes in.
That's where is Lakshana? That's you? Yeah. Dia Ale. Chuguriya. Thank you. Sit down. What a great name.
What language is that?
That's 8 syllables.
Ayala Soma.
16 letters. I think that's nobility. I think that represents a nobility. Was your family a king, or did you have any kings in the family or princes in the family?
I got an email from a prince in
All right,
Africa
so
once.
on Daryl Lewis, there is no answer on Daryl Lewis in 26 CR 1081. A warrant will be issued for his arrest. This is a second-degree felony of sexual assault of a child. What's the bond? 100,000.
With some conditions for
The-
no contact.
The bond is revoked. A warrant shall be issued for his arrest, and bond in the amount of $200,000 is hereby ordered for failure to appear.
Whoa. Just forfeited. He was out on a $100,000 bond.
Those are
Didn't
the
show.
orders.
I needed the indigent. Yeah.
Brad, y'all working on something here on this?
Judge, we're we have a plea deal and
Okay, when you're ready.
Okay.
Don't worry about
Thanks,
it.
Judge.
I've got Rachel Fuller. That's resetting. Dustin's up on Ronnie Linder.
He's president.
There's Mr. Linder.
Judge, on this one, we got blood lab
Two cases, right?
Yeah.
Judge is in a great mood today.
Okay, that was mine. This is old.
It's getting older, Judge. We
It's
got
almost 2 years.
we have blood laboratory records that the experts review, and at this point, we got them probably a month ago. Usually takes her 2 or 3 months to write a report on it. I think the court ordered the records be released probably 3 months ago.
Okay, so what do we do today?
We just need another announcement. I think probably 4 weeks. We may have the report back by then. Be pretty close to the time it takes him.
Yeah, I'm just a little fuzzy on the length of time on that.
Because he hired Mr. Doyle, Peter Doyle, and about 1.5 years went by, I believe, with Mr. Doyle before I got involved. So that's what happened.
It's just, you know what the circumstances are when there's a fatality.
Yes, sir.
People get upset if it's not moved in a reasonable length of time. So you think about 4 weeks ought to be.
Well, it could be close. It could be close about time.
So we're waiting on lab work from.
No, the actual, there's a report that has to be generated by, is it by your expert?
Our expert.
Yeah, by their expert that they have looked at. They've got the results.
Okay.
They just got to have their expert.
And you say 4 weeks.
Yeah, I'm going to
Can you
skip
tell
ahead.
them we need it in 4 weeks? I'll set it for 4
And I
weeks.
mean, that's about the time that she should be done. It usually takes her 2 months, and I think she's had it for.
Then what are we going to do after that?
Well, depending on that report, I'll get you to stay and see if it can be done.
Okay, 4 weeks. Okay. This is on Mr. Lindsay. Tehran Roke.
That's somewhere.
What is his on there?
It's gonna be the same announcement, different reason, different expert. And I think the last time we were here, I think the state may have had some loose ends still. But I know that we're not ready to announce simply because we've got an accident reconstructionist that we'll work on a report for on this case.
We're going to
There's
skip
black
ahead.
boxes and things in this case.
When
Skip ahead to the
is that
trial.
expected?
Well,
That's coming up on a year tomorrow.
That was I'm a little less. That one I don't have as much consistency to work with to know how long it normally takes.
Who's doing it? Somebody out
of Houston, accident reconstructions.
As long as it's not the blue paint
Once
guys,
that
it should
happens,
be
it's a
good.
pretty simple case to try. It's just a matter of arguing over the cost. That's always the issue in these.
Okay.
Yeah.
All right. Hold, please. We're gonna skip ahead to when the trial starts on this one, and we're also gonna skip the jury instructions. So hold on. Let's see. Jury comes walking in. They cover the court, cover the screen. I need to plug your mic in if you want to talk. There you go.
Morning, guys.
That's my wife.
How's everybody doing?
Snow Leopard, I pity the person who bonded that guy out for $100,000 on the jury. 31 months, Snow Leopard makes you an OG. Thank you very much. Well, I'm finding the right spot. How are you doing? Welcome to the land of the living. You're awake now.
You know what? And I wasn't very land of living-ish, but our child, whose birthday it was, kept wandering into the room, and he's like, "Are you going to wake up for my birthday?"
Whose birthday it is?
Yeah, it is. It's his birthday today. So I'm like, okay, yep, let's wake up. Let's make this happen.
Okay. I think.
But the kid who drove with me sacked out, completely unconscious.
All day long. Just clockwise, 3 degrees.
Morning. My eyes aren't that good. I can't see people's names,
just 3
but I
degrees.
can see that you're saying good morning.
The
So
other,
good morning,
the other
everybody.
clockwise. Thank you. Not back. Just perfect.
Nice. Are you doing anything awesome for them?
All right. We now call cause number 24 CR 300, the state of
We're starting
Texas
the case.
versus
Thank you.
Trevontae Nichols. The defendant and his attorney are present, and the state's attorney, and the jury is present. And good morning to all of you, ladies and gentlemen. Thank you for your patience. We've been able to take care of some matters, and we shouldn't be bothered by interruptions the rest of this morning. And at this time, I'm going to swear all of you in as jurors. In this case, please raise your right hands. Do you and each of you solemnly swear or affirm that in the case of the state of Texas versus Trevontae Nichols, you will a true verdict render or verdicts render according to the law and the evidence, so help you God? Lower your hands. Ladies and gentlemen of the jury, by the oath that you have just taken as jurors, you have now become officials of this court and active participants in the public administration of justice. And you are the proverbial we the people. You are going to be making very important decisions that are directly related to the Constitution of the United States in your decision making. And that is a great honor in a democratic republic that we the people are in. If at any time you cannot clearly hear the proceedings, please make sure you let me know. We want to make sure that you can clearly hear everything from this witness chair and also see exhibits clearly as they are being presented here in the gallery during the course of the trial. No one may discuss this case with you during your service as jurors until you go back to deliberate together. And likewise, don't feel offended if you happen to run into the attorneys in the hallway or in the elevator and they do little more than nod to you. To maintain the integrity of the jury system, the law prohibits them from speaking with you until you are released from jury duty at the end of the trial, and they are always anxious to talk to you and get feedback or answer any questions that you may be wanting to ask of them at the end of the trial. And they're available to do that if you wish. If someone does contact you or tries to contact you about this case, please report that at once to one of our bailiffs if this is done while you are jurors. And likewise, don't discuss the evidence in this case with your fellow jurors until the end when you go back to deliberate. And when people find out you were jurors, they want to know what's going on, and be careful because you're not allowed to discuss the evidence in this case, even with your spouse, significant other, friends, or anyone else until you are discharged at the end of the trial. And also, be careful when you read newspaper, watch television reports, or listen to radio reports. If they speak about this trial, mute the sound, turn the page, turn the channel. Again, we don't want you to get information outside of what is presented here in this courtroom. Now, some jurors like to take notes. If you want to do that, that's fine. Those notes, though, are for your purposes only. You are not allowed to show them to others and to note that they might be indicative of some matter. But they can be used to refresh your own recollection if you are jotting them down, so that if you take notes and there's something about a particular matter that you wrote down while during the deliberations, you can pull them out and you can read it. You just can't show them to the other jurors. Now, don't go to any of the locations.
Don't go to any of the locations. Here's your instructions, blah, 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 blah.
And I've written the lead article in Texas for the presumption of innocence beyond a reasonable doubt, cross-examination of witnesses, and deadly weapons.
He wrote the lead
The
article.
inclination of the witness to tell the truth.
Okay, we're going to finish up these jury instructions.
Feel annoyed about that. It's just he'll argue The state had all verdicts are unanimous. I do this all the time because not long, a few years ago, I got a note from the jury that stated we are unable to agree on what unanimous means. And so I wrote back, and my answer was all of you, question mark, exclamation point, thinking, I hope they understood what I just hinted to them, but all decisions have to be unanimous by a jury. At all times, it is your foremost responsibility to see that justice is done in this case in accordance with the law I give to you and the evidence presented. All right, at this time, I'm going to ask the state of Texas to present the indictment, and the defendant shall rise. Thank you.
Here we go. Here are the charges.
The indictment in cause number 24-DCCR-0300 reads as follows. In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the January term AD 2024 of the Criminal District Court of Jefferson County in said county and state, upon oath in said court, present that Trevontae Nichols, hereafter styled the defendant, on or about the 11th day of January 2024, and anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there intentionally and knowingly threaten Philip Bennett with imminent bodily injury, and did then and there use or exhibit a deadly weapon, to wit, a firearm, during the commission of said assault against the peace and dignity of the state.
And that is signed by the foreman of the grand jury.
Yes, sir.
All right. Trevontae Nichols, as defendant in this case, how do you plead to the indictment as just read by the state of Texas? Guilty or not guilty?
Not guilty.
Not guilty is entered in the record on your behalf. You may be seated.
Your Honor, may I read the other two
There's
at this
more.
time? The other two.
And there are two other indictments that have been presented relating to this episode, and the parties have agreed that these will be presented in one proceeding, one trial, and you will treat each indictment separately as to the evidence to those particular allegations, and the state may proceed with the reading in 24 CR 301.
In that indictment, it reads, in the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the January term AD 2024 of the Criminal District Court of Jefferson County in said county and state, upon oath in said court present that Trevontae Nichols, hereafter styled the defendant, on or about the 11th day of January 2024 and anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there intentionally or knowingly threaten Ayana Oates with imminent bodily injury, and did then and there use or exhibit a deadly weapon, to wit, a firearm, during the commission of said assault against the peace and dignity of the state, signed by the foreman of the grand jury.
Trevontae Nichols, how do you plead to the indictment as just read to you in cause number 24 CR 301 as read by the state of Texas? Guilty or not guilty?
Not guilty.
Not guilty is entered into the record. In 24 CR 302, the state may proceed.
The indictment reads as follows. In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the January term AD 2024 of the Criminal District Court of Jefferson County in said county and state, upon oath in said court present that Trevontae Nichols, hereafter styled the defendant, on or about the 11th day of January 2024 and anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there intentionally or knowingly threaten Messiah Bennett with imminent bodily injury, and did then and there use or exhibit a deadly weapon, to wit, a firearm, during the commission of said assault against the peace and dignity of the state, signed by the foreman of the grand jury.
And Trevontae Nichols, as defendant in this case, how do you plead to the indictment in 24 CR 302 as just read by the state of Texas? Guilty or not guilty?
Not guilty.
Not guilty will be entered into the record on your behalf. You may be seated. You can see that what we have is an event that occurred at or about the same time, and the state has alleged in these indictments that there are 3 different victims that are alleged. And just a couple of things, and I know y'all are way ahead of me, but sometimes just to make sure that you're not wondering why these indictments get worded in something that's just not our everyday English. And it's because this is a direct relationship to jolly old England, where we became independent from. And a lot of the old fashioned rules in trials were taken from the method that the English had perfected until we made better use and perfection of it. And where it states, styled the defendant on or about a certain date and anterior to the presentment of this indictment. I don't know why they don't say and before, but anterior means before versus posterior afterwards. But this is again a use of formality from centuries ago. Anterior to the presentment of this indictment, which was this date occurred before the indictment was presented. And then they always use to wit rather than namely, to dash wit, and you use that a lot, but it's the equivalent of namely. And then it ends like it has done for centuries, against the peace and dignity of the state. But centuries ago, this indictments would read against the peace and dignity of the king or queen. Well, we took that right out when we, the people, took over and decided nobility was not the way we wanted to do things. All right, so those are some formalities that are still in use, and there's good reason for all of that, because formalities sometimes make it seem as important as it really is. All right, the state of Texas may make an opening statement at this time if it wishes.
Briefly, Your Honor, may I please report, Mr. Lewis, ladies and gentlemen of the jury. Back on January the 11th of 2024, it was nothing less than a war zone. Automatic gunfire, shell casings raining down like rain, bullets striking vehicles, striking buildings, and civilians ducking for cover. This war zone was not in Iraq or Iran. It was not in Ukraine or in Mogadishu. This war zone was in Port Arthur, Texas. The evidence in this case will show that on January the 11th of 2024, this defendant, Trevontae Nichols, entered the last call liquor store in Port Arthur, Texas in the late evening hours that day. And he was wearing a distinctive all red outfit. No one else in that store, in that liquor store, would either come in or go out during that relevant time period wearing that distinctive red outfit. This defendant would engage a couple of people in conversation there inside of the store. But when the victim entered that liquor store, Philip Bennett, his demeanor instantly changes. He's staring down Philip Bennett. It is apparent, it is obvious that there's an issue with Philip Bennett. Nevertheless, this defendant would finish his business up in the last call liquor store, and he would exit the liquor store. Moments later, those other individuals would also exit the liquor store. The last person before those shots rang out to leave that liquor store was Philip Bennett. Philip Bennett will take the stand, he'll testify. You'll hear from Philip that as he exited that liquor store that evening and got into his vehicle, a vehicle which, by the way, contained his girlfriend, Ayden Oates, and their 7-month-old child, Messiah Bennett. As he got into that vehicle and started to drive away from that liquor store through the parking lot, an individual, mind you, just moments after leaving the store, and just moments after Philip Bennett left the store, individual wearing an all red outfit can be seen coming from around the side of that liquor store building and firing a firearm in rapid succession at that vehicle as it drove away. And then after firing those shots, this individual in that red distinctive uniform or outfit, excuse me, would leave that area and run back behind that building, the liquor store building. Now, mind you, the evidence will show that Philip Bennett's vehicle, as it left the parking lot, it was making a left turn, essentially putting itself in behind the liquor store, if you follow me. You've got now the defendant who has run back behind the liquor store and the vehicle of Philip Bennett that's now behind the liquor store. Philip Bennett sees this individual along with other suspects with firearms, and an exchange of gunfire occurs again. You see, Philip Bennett had his own firearm with him. And Philip Bennett opens fire at this point. I believe he will testify that he did so in self-defense. He did so out of fear. He did so thinking he needed to do that to protect his girlfriend Ayana and their child Messiah. There would be no less than 80 rounds exchanged. You'll hear from the evidence tech who came out to the scene and collected the shell casings. You'll hear her testimony that she'd never been to a scene where she had collected that many shell casings. You'll see photos, crime scene photos that show bullet holes that struck the side of the liquor store building and actually entered into the building. You'll see crime scene photos that show the vehicles, at least 2 vehicles, maybe 3, parked in the parking lot there that were struck by bullets that were flying across this parking lot. You'll see crime scene photos that show that those bullets traveled as far as across the street and struck a Valero gas station, the side of that building. You'll see surveillance video, not only from the last call liquor store, but surveillance video from that Valero gas station showing people ducking for cover. Speaking of that video, you'll see surveillance video from inside of that last call liquor store showing this defendant, Trevontae Nichols, entering that liquor store wearing that red outfit. You'll see that video of Philip Bennett entering the liquor store. You'll get to assess and size up this defendant's demeanor and how it changes and how he's staring down Philip Bennett just moments before those gunshots rang out. You'll see the gas station video from across the street, the Valero video, showing an individual just moments after that interaction between the 2 of them inside the store with that red outfit, running after that car, firing those shots. And I'll just say this up front. It's not the best video. We've done our best to enhance it. We think that helps. But you're the final judge of the evidence and the testimony in this case. You make the call. But at the end of the day, you'll see those crime scene photos. You'll see the video. You'll hear from Philip Bennett, Ayana Oates. You'll hear from the officer, at least an officer or 2 that responded to the scene, and the detective that put this case together. And at the end of the conclusion of this case, and the presentation of the evidence, I'll ask you to use your common sense. I'll ask you to use your reason. I'll ask you, like we talked about jury selection, to put the pieces of the puzzle together and come to the only conclusion that I believe the evidence shows, and that's the conclusion that this defendant, Trevontae Nichols, is guilty of aggravated assault. Aggravated assault against Philip Bennett, Ayana Oates, and that the baby, Messiah Bennett as well. Thank you.
All right, and Mr. Lewis, do you want to make an opening statement now?
Is he reserved?
You may.
Thank you.
All right, let's hear their defense.
Good morning,
Sounds
everybody.
like it's all on video.
Now, this is the first time you actually get to hear from me when we talk about the actual case we're dealing. Okay, you talk about the evidence you're going to get to see and the testimony you're going to get to hear. Now, does everyone remember the hypothetical that we talked about when I talked about car A versus car B? Okay, from this point on, I definitely want you to keep that in mind as you get a chance to see and hear each piece of evidence that's going to be presented. Because a big part of this case is going to be perception versus reality. Okay? Perception versus reality. And a lot of times, some people's reality is really based off their perception of what they may have seen, may have heard, and may have witnessed. Okay? So in this situation, we have to use a totality of the circumstances of everything we'll get to see for you all to be able to make a decision about what you're gonna decide in this matter. Now, as Mr. Coleman talked about, you will get to hear from some witnesses who will talk about the interactions between my client, Mr. Nichols, and them inside of the store that evening. And you'll be able to make your own determination if there was ever any issues between them. That's your determination to make. And then you'll be able to see the videos that they're talking about of the shooting that happened in this distinctive outfit. And you'll be able to make your own determination if you're seeing the distinctive outfit that is described by the state as far as being worn by my client, or it's something different, or someone else, or even the same size as my client. You get to make those determinations from looking at this evidence. Okay. And main thing I'm asking of each of you is just to keep your open mind and stay focused when you get to hear each piece of evidence before you make that determination. Okay. And each of you, even though you have to all come together and unanimously make a decision, I do ask each of you to be steadfast in whatever your determination is of what happens that evening. Okay. Now, not going to get too far ahead of myself as far as, because once after everything is presented, you'll be able to basically get instructions and everything of how to proceed and make your decision and determination of the verdict. But I am confident that once you do hear all the evidence and see all the evidence that's going to be presented, there's only one real option you'll have, and that is to find my client Trevontae Nichols not guilty of this aggravated assault. Okay, so like I told you before, in Rodire, I look forward to putting on this case and trying this case before you. And just as I said before, just keep that open mind and pay attention to everything that's going to be presented. Okay, thank you.
All right, the state may call your first witness.
All right, this time the state calls John Bowen. Bowen. John.
So we are underway with our first witness, if we can find him.
Come forward, please.
Last call.
Raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Please have a seat. Thank you.
Thanks, Red Pen, for the thumbnail. Thanks, Josh, for the spelling correction. Fixed them both. Trevontae. Oh, yeah, I got an extra.
Thank you, Your Honor. Good morning, Mr. Boland. Would you please state your full name for the court reporter and for the ladies and gentlemen of the jury?
John Clarence Boland, Jr.
And Mr. Boland, how are you employed, sir?
I'm employed with the Florida Police Department as coordinator of support services over dispatching records.
Over dispatching records, is that what we normally would refer to as 911 or 911 dispatch?
That is correct. We are a PSAP.
You're sorry?
A PSAP. We are a 911 service.
911 service. Do me a favor, Mr. Boland, and speak up. I want to make sure all the jurors can hear you. Pretend like you're speaking to the furthest juror over there. How long have you been with the dispatch or 911 service?
I've been there for right at 4 years.
Okay. And in your capacity, what is your capacity there?
So I'm the division head over the records and the 911 center.
And in that capacity, are you familiar with the recording equipment maintained there at the 911 center or dispatch?
Yes, sir.
And is it, how does that work? Does it work automatically when calls come in?
Yes, sir. It covers all audios from our 911 calls to landlines and our radio traffic.
All right, there's that. Do you have any reason to believe that back on January the 11th of 2024, that recording equipment was not properly operating?
No, it was properly operating.
That equipment, as you know it, is it capable of making inaccurate recording?
Yes.
Inaccurate.
And,
You said it again.
Was a recording of a 911 call made, as far as you're aware of, at around, give me a second here. Around 10 p.m. on January the 11th of 2024.
Yes, sir.
All right. And have you had the opportunity to review and help me with the terminology? Is it event report or dispatch log?
Call for service report.
Call for service report. Have you had an opportunity to review the call for service report related to that time period or time frame?
Yes, sir.
On that particular day?
Right.
And did you have an opportunity to associate it with a recorded 911 call that was made?
Yes, sir.
May I approach the witness?
Yes.
Rachel B., thanks very much for the sunshine.
What I would mark as state exhibit number 1.
What are we going to count this time?
I'll ask you for the record to describe this device first before we talk about it. What kind of device are we looking at?
As a USB.
And what's contained on this USB drive? Is it the 911 call that you just been testifying about?
Yes, sir.
How do you recognize this particular USB drive?
That has some that we give whenever we ask to have our audio recorded polling for the DA's office.
But
And
more-
it has
More
my,
simply, yeah, that's what I'm getting at.
my initials, time and date.
That's what I'm getting at. You recognize this particular USB because it has your initials, the time and the day, signifying what?
Signifying that I'll listen to that audio.
And when was that? When did you listen to that?
This morning at 9 a.m.
Do you have any reason to doubt that it was a 911 call made on January the 11th, 2024 to the 911 dispatch center there in Port Arthur?
No.
Any reason to doubt that this is a fair and accurate copy of that 911 call made on January the 11th, 2024 to the dispatch center there in Port Arthur, Texas?
No.
Your Honor, this time states 1, and for record purposes, it's been previously provided to defense counsel in discovery, but I'll make it available to him now for his inspection. It's just audio.
No objection.
State's Exhibit 1 is admitted.
Permission to publish, Judge.
And that?
Hello, 911, what's your emergency?
I just lost my life. Somebody got this. Trevontae Nichols just got in my car while my baby was in here. I got in on that last call.
Wait a minute, what happened? Hey, listen, what happened?
And the police just go, okay. Why nothing happened?
Wait a minute, what happened, sir?
Literally fighting for my life. I'm watching the camera.
Okay.
Yeah, the camera if y'all want.
Are you listening to me?
So today, I want to launch my budget.
Stop talking. Stop talking and listen. Where are you right now?
I'm on the way to be talking right now.
Pull over to where you're at. Pull over.
Now, I'm not, I can't. I'm in the middle of traffic now. You can meet me at Academy if you want to. But
where are you calling in reference to?
So I'm just trying to.
Are you listening?
Yes, ma'am. I'm listening.
I'm asking you, what are you calling about?
I just got in the shootout.
You got into a shootout with who?
Well, my new baby is
Listen.
my new
Listen.
My did you get into a shootout with? Trevontae Nichols. Trevontae Nichols. Hey, stop talking. Stop talking and just answer the questions I asked you. Trevontae Nichols. Listen. What? Stop talking. What is your name? What is your name? Your name? Phil Dennis? What did this happen at? This didn't happen at last call. At last call? Fucking guys like that just fucking happened. Listen. Did you flag the officers down? I'm fucking pissed. Stop talking. Good. And listen. Did you flag the officers down when you saw them? Yes, they kept going. Okay, it just happened that you're okay. What type of vehicle are you in? I can't get nothing out of it. He's not listening. What color? What Kia Sorento? A gray. I'm working in front of a gallery right now. So you just had a shootout with somebody on Gulfway. You're with Rory at Academy. Yeah, because I have to get more pussy because my fucking baby. I'm not gonna let them just shoot my car up. No, no. I'm not gonna let them just fucking do that. No. No, I'm not. Don't fucking let them. Okay, do not go inside until you call. Okay, he's trying to buy more bullets. I can't let them fucking. Now, I'm defending myself. They just got my fucking car. They just got my fucking car now. And I'm not having that shit at all. Yeah.
Okay, we don't have the world's best
Some questions I have is
911 caller, but we also might have the world's worst 911 dispatcher. Listen, stop talking.
Mr. Boland, now you said that you basically worked as within the 911 dispatch services. Did you go any further into this investigation or anything like that in regards to my client, Mr. Nichols?
No, sir.
Okay. It was only into the preservation of the 911 call. Is that correct? Okay. No problem. Pass the witness, Judge.
Anything else?
No, Your Honor.
Then this man is excused. Thank you. Next, please.
This time, state calls Officer Gloria Sela Gonzalez.
Officer Gonzalez, next up. Call the dispatcher to the stand. Can we FOIA request all her calls from that day? Did she just have a bad day or what? Who did you get in a shootout with? Why are you asking who the other shooter was? Is it more important that if there's somebody injured?
Please come forward. Thank you. And raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Please have a seat.
Have a seat. This judge should read books, audiobooks.
G-O-L-R. Y-C-E-L-L-A. Yes, two Z's. G-O-N-Z-A-L-E-Z.
Morning, Officer Gonzalez. Would you please state your full name for the ladies and gentlemen of the jury?
Gloria Sela Gonzalez.
All right. And Officer Gonzalez, it sounds like you've already spelled your name for the court reporter, which was my next question. Please correct me if I mispronounce it. It's Gloria Sela, correct? Mm-hmm. All right. Yes, very good. How are you employed, Officer Gonzalez?
I now work for the constable's office, precinct 6.
Okay.
I've been there a year and a half. Prior to that, I was in Port Arthur Police Department for 8 years.
That's what I was getting at, is your time with the Port Arthur Police Department. Were you there? Well, first of all, are you a certified peace officer?
Yes, sir.
And were you a certified peace officer back on January the 11th of 2024?
Yes, sir.
And you were employed with the Port Arthur Police Department back on January the 11th of 2024,
yes,
correct? At around 10 p.m., did you receive a dispatch?
Yes, sir.
And please tell us the nature of the dispatch and the location that you were dispatched to.
Dispatch advised that there had just been a shooting that had occurred at Last Call Liquor on Gulfway Drive.
Okay. And Gulfway Drive, that's in Port Arthur, Texas?
Yes, sir.
And Port Arthur, Texas, of course, is in Jefferson County, Texas, right?
Yes, sir.
What did you do after receiving that dispatch?
I responded to the call, and upon arrival, I noticed that there was a whole bunch of shell casings in the parking lot.
Let's do this. Let's orient the jury as to the area or the location that we're talking about. May I approach the witness? Officer Gonzalez, I am going to show you where I'm marking as states exhibits 2, 3, and 4. You to take a moment to look at these and is it fair to say that those are Google Map or Google Earth Map representations or depictions?
Yes, sir.
And do you have any reason to doubt the accuracy? Does it, as far as you are aware, fairly depict the area that it is purporting to depict?
Yes, sir.
Do you think it will help this jury or assist this jury in understanding their testimony if we're allowed to utilize those maps?
Yes, sir.
Your Honor, at this time, State Officer states exhibits 2, 3, and 4, and I'm tendering to defense counsel for his inspection. All right. State's exhibits 2, 3, and 4 are admitted. Permission to publish, Judge. And that is granted. Oh, control. All right, for the record, displaying what's been marked as state's exhibit number 2, the Google map there. The general area, Officer Gonzalez, and if it's helpful and if it's allow,
dim the lights. I think the jury can.
Just gonna.
No.
Oh, that's right. It's going to work against the
projector.
The projector. We're going to need a projector. And
if the court will allow maybe you to step down and point and kind of orient the jury as to the landmarks, what we're looking at. First of all, is this a map of the Port Arthur area in general?
Yes, sir.
Would you point out the major thoroughfares and where Last Call Liquor would be located?
This is Gulfway Drive. This way it runs east and west, and this is Woodward. It runs north and south. This street right here is Bluebonnet, and this store is located right here on the corner.
Oh, all right. Let's take a look at State's Exhibit number 3. Is it fair to say that State's Exhibit number 3 is a more zoomed in version of State's Exhibit number 2?
Yes, sir.
Again, orient the jury, please.
Again, this is Bluebonnet. The store sits on Bluebonnet and Gulfway Drive right here. And there's another store that's catty corner from it called Shortstop that's right there.
Does Shortstop sell gas as well?
Yes, sir.
Valero's gas, if you know, is it sometimes referred to as the Valero gas station?
Yes, sir.
And lastly, State's Exhibit number 4 is an even more tighter shot of that area. Is that fair to say?
Yes, sir.
Again, where's the Last Call Liquor store?
It's right here. And this is Gulfway.
That's Gulfway. And the gas station again?
It's right here.
I won't hold you to it, but if you had to estimate
Walmart?
How many feet or yards away or apart the Last Call Liquor store is from that convenience store or the Valero gas station?
I have no idea. I'm terrible with measurement.
Sure, but it's fair to say it's essentially
Yeah.
across the street.
Yes, sir.
Now, behind that gas station, well, let me ask you this. I think it will be important later on in future testimony about where St. Augustine and Blue Bonnet meets. So I'll ask you to point out for the jury.
They meet right here on the side of the store.
Okay. Okay, very good. Please take your seat there.
Just to help the jury, is that the canal that's on the
Thank you.
left side?
Judge, say
And
Walmart.
then Pleasure Island is on to the left of.
Yes, Pleasure Island is on the west side of here. So if you go further down Gulfway, Pleasure Island is over here.
Thank you.
Pleasure Island? Is that a thing? Sounds like an Epstein.
So that's where you responded to.
Yes, sir.
That particular location. Please describe to the jury, ladies and gentlemen of the jury, kind of essentially from a broad perspective, what you observed when you arrived on scene.
There were multiple shell casings in the parking lot, and then on the east side of the building, there was multiple bullet holes on the building.
Okay.
And a couple of vehicles that had bullet holes in them as well.
Okay, I don't.
Is it fair to say that you talked to several witnesses or prospective witnesses when you arrived?
I spoke to 3 gentlemen that were inside of the store.
And please don't get into what they said because it's hearsay. But I just want to make sure we point out you did at least talk to some individuals. Right?
Yes.
Oh, good. Were you there on scene when ID arrived? Crime scene tech, or what we refer to as ID?
Yes, sir.
Okay. And when they arrived on scene, what did they do?
I helped her with the markings of the shell casings and the bullet holes on the side of the building.
All right. Now, that day, were you equipped with any recording device or equipment?
Yes, sir. I had my body cam.
And your body-worn camera, was it properly operating as far as you know?
Yes, sir.
You, as the operator of that body-worn camera, you're certainly capable of properly operating that camera?
Yes, sir.
And were the scenes and your interactions there at that last call liquor store when you arrived, was that captured on your body-worn camera?
Yes, sir.
May I approach the witness, Your Honor?
Yes.
Yeah, Pleasure Island and Last Call Liquor is a recipe for just another terrible decision.
I'll show you where I'll eventually mark as State's Exhibit number 5. I'll ask you
It's an actual island?
whether or not you recognize State's. Well, first of all, for the record, what kind of a device are we looking at?
A USB drive.
Okay. Do you recognize that USB drive?
Yes, sir.
How do you recognize that USB drive?
I just viewed it in the chambers.
And you know that how?
I know it.
How do you know that? How do you know
that? It's mine.
Well,
I viewed it in
Oh,
chambers.
because I initialed it with the date.
yeah, this post-it note that's attached to it, you initialed it and dated today's date.
Judge's
Yes,
letter.
sir.
It's
And
mine.
that indicates that you watched it today. In fact, when did you watch it?
Right before coming in here.
Okay. But for the redactions that we've made
What's a
that are
but
necessary for this trial, is this a fair and accurate copy of your body-worn camera?
Yes, sir.
In fact, the redactions that I'm talking about is we've essentially taken out all of the sound.
Yes, sir.
You're not going to hear your conversation with the witnesses.
No, sir.
Your conversations with the other officers.
No, sir.
But other than that, it's a fair and accurate copy.
Yes, sir.
Your Honor, State Officer States 5 has been previously provided to defense counsel in discovery, and I tendered to him for his participation.
No objection.
No objection, Judge.
Admitted.
Permission to publish, Judge?
That's granted.
Please don't turn off the lights. Please, 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 Judge. Just forget to ask the bailiff to turn them down. It's fine. Don't say it. Don't say it. They turned the lights off anyway. You can sort of tell something's happening. It's a silent
Is this
video.
the inside of the liquor store there?
Yes, sir.
Are you just shopping for some of the good stuff?
What are we looking at there? For purposes of the record, we're about 1 minute and 20 seconds into the video. What are we looking at there?
A bullet hole.
In that particular vehicle?
Yes, sir.
I've always heard there are only 5 parts of a car that will stop a bullet. 4 of them are the wheels or the rims on a wheel. The last one is the engine block. Car doors, no bueno. Unless you've got very specialized equipment.
It's like there's something in your hand. What is that in your hand?
I found a wallet that was on the ground.
Okay.
I like having a butt 4 on the bingo card. Because then people are like, what's a butt for? Oh. Tai Chi Lemur.
I'm sorry, that was gloves I was grabbing.
Sign me up for a copy of this book when you write
But
it.
nevertheless, at some point you did collect a wallet.
Yes, sir.
It was on the ground there.
Yes, sir.
So we have bullet holes in cars, bullet holes in the liquor store wall. Did they hit any bottles on the inside? And shell casings all over the parking lot. There's going to be some
Is
video.
that the wallet?
Yes, sir.
There's a wallet. There's going to be a video from surveillance video on this store or the one across the street that may capture this whole event as it plays out. We're just going to have to take their word for it if they turn the lights off. The flashing you see in the courtroom video above is not the camera overreacting to the dark picture. That is the strobe of the police lights, I think, playing out, reflected in the courtroom. A to wit is going to be in every single indictment if you put to wit on there. That's like, you can't have an indictment unless you have to wit in there. It's the rules. The defendant appears to be using the shaggy defense in this trial.
For purposes of the record, we are about 5 minutes and 50 seconds into the video. What are we looking at, or what are you focusing on at this point?
The bullet holes on the building.
For purposes of the record, we're about 11 minutes and 40 seconds into this video. Who's that individual that you're speaking with there?
The crime scene tech, her name's Deanza.
Okay.
"11 minutes into the video and the crime scene tech's already there? That's impressive. She's a first responding officer, right?" Judge grabs his Slurpee for a refreshing gulp. I think the prosecutor is skipping through this a little bit. This will all go back with the jury. If they want to watch the whole thing, I'm sure they can.
If you recall what's going on, we're at about 16 minutes and 29 seconds. Crime scene tech, Deanza Bowler, what is she doing at this point?
Marking where that vehicle got bullet holes in it.
This is a separate vehicle from the one before, right? This is
Yes, sir.
pickup truck now. The other one was a passenger vehicle, correct?
Yes, sir.
Everybody's cars are getting shot up in this thing. What's the defendant thinking? Is he thinking, I don't know how they could pin this on me, I didn't do it? Or I can't believe I missed that many shots?
And 16 minutes and 45 seconds into the video, what are you doing now?
We're marking where all the bullet holes are at on the side of the building.
Officer Gonzalez, let me know if this is a more appropriate question for ID Tech Bowler, but in your training experience, have you come to be able to distinguish between a fresh bullet hole and maybe a bullet hole that has been there for some time?
Yes, sir.
Did you form an opinion based on your training and experience if these were fresh or newly or new bullet holes?
Yes, sir.
And what opinion did you form?
Deanza me and her had discussed which ones were new, and she told me which ones to mark off.
Oh.
Pretty sure this all started when they were fighting over the last bottle of Pappy Van Winkle's Family Reserve 23-year specialty bourbon. And pre-existing. Yeah, I'm just glazed over that, but you're right, Greeners. We have concern about pre-existing bullet holes in both the store and the vehicles. It's like, no, those ones are already there. That was something else. Don't worry about that. That was good. There's another story to be told somewhere. The only reason I know about Pappy Van Winkle's Family Reserve is because in Utah, where the state runs the liquor stores, they have a law that requires them to sell the liquor at a certain price compared to how much they pay for it. And with the Pappy Van Winkles, when one of these cases gets shipped to the liquor store, they get it at a pretty low price, but the store is not allowed to mark it up to the demand price, which can be thousands of dollars. They have to sell it dirt cheap. And so there will be a run on the liquor store. Even people who don't drink will run down there to buy to buy these bottles and then turn around and sell them on the secondary market and 10x their money. I think the pre-existing bullet holes in the neighborhood might be why there's not a Walmart in this trial. Any relation to Rip Van Winkle? I don't think so. Maybe distant relative. Speaking from experience, I loved retail arbitrage.
For record purposes, we're about 21 minutes and 55 seconds into the video. What is that ID Tech bowler is carrying in their hands?
That's some cones for us to mark off all the shell casings that were in the parking lot.
Okay.
I tried to get a bottle. I couldn't. They were sold out before I could get one. I have no idea. I don't drink, so I don't know what's so good about it. But I guess they made it like 20 years ago, and they only make a very few of them. So
and 23 minutes and 3 seconds into the video, is that in fact what ID Tech Bowler is doing? Is marking the various shell casings in that parking lot?
Yes, sir.
All right, are we done? We start another video.
That's all I have on that, Church.
Lights.
Thank you.
Okay, thank you.
Aziz, lights.
Officer Gonzalez, did you essentially stay on that scene until that scene was processed and it was released?
No, I left.
Okay. Did you? Well, let me back up.
Got boring.
I just want to make sure we get this on the record, and you're as good a witness as any to get this on the record. Is a firearm in your training and experience considered to be a deadly weapon?
Yes, sir.
It's certainly capable of causing serious bodily injury or death, correct?
Yes, sir.
While you were on scene, did you send an officer, and correct me if I'm pronouncing the name wrong, is it Charlotte?
Yes, sir.
Charlotte or Charlotte? Charlotte, you send Officer Charlotte a video, or at least a video of the video from the last call liquor store?
Yes, sir.
For what purpose?
To identify the suspects that had gone into an altercation inside.
Okay. And without saying what Officer Charlotte told you, because that's hearsay, did he in fact at least indicate that he knew or recognized a subject or subjects in that video?
Yes, sir. He knew all.
Okay, good.
Thank you, Pen
and did you, when you were done there, at some point, did you prepare a report indicating your involvement in this particular case?
Yes, sir.
And did you do so at or near the time when those events were still fresh on your memory?
Right after, yeah.
And, it's been nearly 2 years since you responded to few or many calls since that time?
Yes, sir.
Many?
Yes.
Do you remember each and every detail about each and every call?
Yes.
Have you reviewed your report prior to testifying here today?
Yes, sir.
And did that help to refresh your recollection about that day?
Yes, sir.
Thank you, Officer Gonzalez. Your Honor, I'll pass the witness.
Defense is going to ask, why did you leave the crime scene?
Morning, Officer Gonzalez. Now, you say, of course, you're with the Sheriff's Department now. Constable's office.
Yes, sir.
Sorry. But you were with the Peralta PD back then when this allegation occurred.
Yes, sir.
Correct? And how long did you say you worked there?
8 years.
8 years? Okay. Now, in that time of 8 years, would you say there were many different scenes that you had to arrive to and investigate?
Yes, sir.
Okay. Plenty times when you had to deal with open shell casing that will cover an entire perimeter.
No, I haven't worked with that many with a ton of shell cases, not like this case, no.
But when there were actual examples of actual open
Yes.
shell cases at the scene.
Yes.
Okay. Now, were you the first person to arrive at this location? Do you remember?
I believe so.
Okay.
Yes, sir.
So when you left, when you got there, you were first or one of the first officers at the scene. Did you establish that perimeter?
Yes, sir.
You did?
Yes, sir.
Okay. And when you said the shell casings, were those shell casings involved or around that entire scene?
Yes, sir. In the whole parking lot.
Whole parking lot. Okay. Now, from your experience and seeing these shell cases, could you tell how many possible weapons or caliber of weapons that were involved in that at the scene that night?
Without looking at the shell casings, no. But with looking at the shell casings, you could tell, it was possibly more than one.
There's possibly more than one?
Yes, sir.
Possibly more than two?
Possibly.
Okay. Now, you said at some point, you not only did the initial investigation for us talking with the people inside of the liquor store, but you helped the ID tech as well.
Yes, sir.
Okay. And in helping the ID tech, what exactly, now we can see a lot from your body cam, but what exactly were you doing as far as?
Showing her where the shell casings were outside and inside of the business, along with on the side of the business where the bullet holes were.
Okay. So your assistance with her was more or less to identify where everything was located.
Yes, sir.
Okay. It didn't go into actual any photographing or labeling of any of the shell cases.
No, sir.
Okay. Now, as far as that perimeter that was established, how far, in your opinion, was that perimeter, or how wide did it go out?
I'm terrible with measurements. Terrible. I mean, like the whole parking lot. You can see in the video.
Right. Did it go further than the parking lot as far as behind the store or around the?
Some on the side, some shell casings on the side where we were marking off the wall.
Right.
Area on the side as well.
Okay, so your focus mainly was to the front of the parking lot and the side.
Yes, sir.
Of the store.
Yes, sir.
Okay. And you said at some point you left though, right?
Yes, sir.
What, I guess maybe hard to say, but if you know, where exactly or what stopping point or where you were in the investigation or the department was in the investigation at the time you left the scene?
I believe they were almost done. I was on overtime. I'd been there since 5:30 in the morning. So This was at 10, 11 o'clock at night.
Yeah.
So once I passed it over, they're pretty much done with the scene.
Okay. And whenever you leave a scene like that, did you have to, like say, pass your duties on to a particular officer at that time?
No, because I think we were done. The only person that was left was the ID tech, and an officer stayed with her until she was done finishing the scene.
Okay. And do you know, I know you said you had to review your report and everything to refresh your recollection, but do you remember who might have been involved with helping the take during that time?
No, sir.
Okay. Did you have any other involvement after you left the scene that night into the investigation of these allegations against my client?
Did I have any
other?
It's the last call liquor?
Yeah. Did you have any other?
Sending the video to Officer Charlotte?
Right.
I went to Academy.
You actually went to Academy?
Yes, sir.
Okay. And what did you do once you got to Academy?
The victim had called and stated that he was Academy, so we went up there with him.
Okay. So you made contact with the victim at Academy?
I believe Officer Broussard had him in his vehicle, so I honestly don't remember.
Okay.
I just remember we had to grab the car seat out of the vehicle and give it to victim's girlfriend because they had a 9-month-old with them at the time.
Right. So,
But it's in your
when you
report,
went
right?
to academy, did you have to make contact with anyone that was involved?
No, I didn't personally talk to anybody, no.
Okay.
They just asked me to grab the car seat out of the vehicle so they could take the 9-month with them because we're gonna process his vehicle.
Okay.
So I followed the tow truck with his vehicle back to the Port Arthur Police Department so it could be processed.
Okay. And once the car was followed followed the tow truck back, did that
That's
end?
when I was,
That ended your involvement?
yes, sir.
Okay. Did you have any other involvement in this investigation after
No,
that?
sir.
Okay. Pass the witness to us.
No further questions, Your Honor.
Is this lady excused?
Yes, Your Honor.
You are excused, ma'am. Thank you. Next, please.
Your Honor, the state calls Deanza Bowler.
This might be the other body cam or the other video of the actual shooting.
Okay, so wondering why you were keep hanging on.
Please come forward. Raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And please have a seat. Thank you, ma'am.
Crime scene tech.
You please state your full name for the ladies and gentlemen of the jury and spell it for the court reporter.
EANZA, last name BOHLA.
And Ms. Bowler, how are you employed, ma'am?
I'm a forensic specialist with the Port Arthur Police Department.
Otherwise referred to as a crime scene or ID tech? Okay. And how long have you held that position?
I've been with the department 5 years. I've been in crime scene for 3.
Okay. And I think the ladies and gentlemen have a working idea of what a crime scene tech does, but please, in your own words, explain to them what your duties are.
Yeah, we're responsible for documentation of the crime scene. So we'll go in, take photographs, and collect videos of anything that occurred. We'll also collect evidence, preserve the evidence, and we're responsible for the chain of custody of that evidence.
And did you have an occasion or an opportunity to do just that back on January the 11th of 2024 at the Last Call liquor store located at 2301 Gulf Way in Port Arthur, Texas?
Yes.
And that location is also in Jefferson County, Texas, correct? And the jury has already heard testimony from Officer Gonzalez about the scene, so I'm not going to spend much time on it as far as your observations, but only to say, give them like an overview of what you have observed just in general terms when you first arrived on scene.
Yeah, pretty chaotic. So, the building had been struck multiple times, and there was also multiple vehicles in the parking lot that had been struck. We had multiple shell casings in the front of the parking lot near the entrance of the vehicles that were struck. And then we also found out later that the gas station across the street had been struck, and I was able to locate a second cluster of shell casings kind of towards the east of the building as well.
Okay. And of course, when you do so, you photograph those shell casings. You photograph any bullet holes or defects in the building or vehicles, right? You do that?
Yes.
Okay. And you did so in this case, right?
Yes.
Just if you had to estimate, if you had to guess, how many photos do you think you took at this scene?
Over 300.
And it's quite a few, and that's by design, correct?
Yes.
Why is that? Why do you take so many photos?
So that the scene is accurately depicted, where somebody who wasn't on scene, it might get confusing. So we through our training do it in a way that it makes sense. So we start with our overall photograph so you understand the location of the scene, and then each piece of evidence is marked with the evidence marker that has a number on it. So that number is going to be correlated with that evidence item. And then we'll take individual photographs of those So you know that like that showcasing is item one and so forth.
And is it also fair to say that you take so many photos because you never know what may become important or relevant over the course of the investigation? Is that fair to say?
Yes.
Yeah. And may I approach the witness?
Yes, sir.
Ms. Bowler, been attempting as I was questioning you, multitasking, start to mark these various photographs here. I don't know. I'm going to try something different here and try to do these in batches this time. 30. And the first batch of photos I'm going to refer to as just photos of the store and its parking lot. And I've marked those as state's exhibit numbers 6 through 30. I'd ask that you take a moment to flip through those and let me know if you recognize them. And while you're flipping through those, I'll start marking the next batch.
Whole bunch of photos going up. You have to realize she took pictures of all the shell casings, and they said, what, 80?
Do you recognize those?
Yes, these are the photographs
18,
that
I don't
that
know.
night.
And are they fair and accurate depictions of the photographs that you took that night?
Yes.
They don't appear to be have been altered or manipulated in any way?
No.
Your Honor, at this time, well before I offer 6 through 30, let me do this. I ask that you take a look at the next batch here, states 31 through 37. What I'm referring to is photographs from behind the last call liquor store.
Okay.
Do you recognize those?
Yes.
Same questions. Are they fair and accurate depictions?
Yes, they are.
And that they don't appear to have been altered or manipulated in any way?
No.
All right, let's move on to this next batch here that I have marked as states exhibits numbers 38 through 48, what I will refer to as photographs of a looks to be like a GMC pickup truck there at the scene. Let me know if you recognize those.
Got like 2.5 hours of sleep last night. It wasn't enough.
You recognize those?
Yes.
Fair and accurate depictions
Yes, sir.
appear to not have been altered in any way.
Right.
Showing you the next batch, I've marked the state's exhibits number 49 through 64, what I'll refer to as photographs dealing with a passenger vehicle, Nissan passenger vehicle there at the scene. You look at those and tell me if you recognize those. Fair and accurate depictions?
Yes.
Appear to have been altered in any way?
No, sir.
And lastly, state's exhibits 65 through 69, where I'm referring to is photographs of the Valero gas station or convenience store that's across the street from the last call of the store. Fair and accurate depictions?
Yes, sir.
Unaltered? Now, again, you took hundreds of photographs.
Yes.
And is it fair to say that state's exhibits 6 through 69 they're just a representation portion of some selected photographs that we pulled out first of those trial, right?
Exactly.
Out of this time state office states exhibits 6 through 69. They've been made available to defense counsel in discovery, and I'm making it available to him now for inspection.
Marvin, have you had a chance to look at those yet?
I believe so, Judge.
Okay.
Yeah, I have. Judge, no objection.
All right. Without objection, then states exhibits 60 through 69 are
6 through
admitted.
69.
I'm sorry, 6 through 69 are admitted. Sorry.
Thank you, Your Honor. Permission to publish?
Yes. I'm going to ask for this. We're going to have to take a break. I've got to attend a meeting for the county here shortly, and I'm going to ask all of you if you would be so kind to remember where we are and have a nice lunch. Report back at 1:00, and we will pick up where we left off. And if you'd be so kind to meet with us back at 1:00, and thank you, Judge.
Yeah.
Yeah, hold on. It's gonna, 1:15, we have, they reminded me, there's a capital murder case that is going to be dealt with at 1:00 that has nothing to do with this. And that has a special, those are very unique and special. And we're gonna probably need 15 or 20 minutes on that. At 1:00, we've got that scheduled for 1:00, and that will be disposed of by 1:20. So I'm going to ask you then to come back at 1:20. Okay, 1:20. Thank you very much.
Thank you.
All right. Everyone else remain seated while the jury exits first. Also, in the basement, they've got a food kind of court downstairs in the basement.
And a foosball table.
Pretty good food down there.
So
also there are places around town here close by.
Yeah, coming in now.
Yes. Bring my
Sir,
can I bring my notepad for the sake of
yeah, sure.
with their computers?
You just
Can you grow up? Thank you very much.
any notes you write, those are just for yours, and you can refresh your memory all day long, even during deliberations, but you can't show them.
Yes, sir.
Yes, sir.
Thank you.
Anything else? We're in short recess, 1:30. 1:30. Thank you for lunch. All right, we're in recess.
We're in recess. Food court in the basement. RA is not waking up in an hour, y'all. Whatever. I just built the new portal. I just built the portal to get us transferred over there. Still have to put the thumbnail on it, but just 1 second. I think an hour's nap is all I need, for sure. I'm going to go take a nap. I am going to go take a nap, for sure. Let's see. Let's watch the capital plea. What time were we coming back? He said 1:20. What state are we in? Boom, 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 boom. We're in Texas, right? So 2:15 Eastern. Lois, thank you so much for doing the math. I'm not in shape to math today. Let's redirect to that one. Trevontae Nichols. It's a pretty good little case here. I'm liking it. Let me just set the start time for the 2:15. Starts at customization. months is it? Nope, that's not it. Hold, please. There we go. All right. Okay, portal's in place. Greener's won the internet, I think. Let me check. Yep, Greener's won the internet. We're all good. We're all good. All right, I'm going to go wish my son happy birthday. He came in here, we sang happy birthday to him. He opened his present. He's like, I knew what this was. And then he came to us with a confession. He said, by the way, one time on Amazon, I accidentally clicked order on this and then hurried and canceled it. So at least it's something he wanted. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about an hour and 15. How do I get to the portal? The portal comes to you, Brian. Lucky day. Just stay right there. As soon as this one ends and the spinning wheel starts, give me just a second, and it will say, we're being redirected. It will send you over to the new one. Just make the jump. Grab somebody's hands. Make the jump. Once you've done it once, you can do it again. Welcome. We'll see you guys in the afternoon. Have a good one. Bye-bye.